Hello, Lyric Armstrong, your real estate agent and advocate. Okay, so we're still in 3D Judge Milton's court. We're breaking up videos to make it, a little less cumbersome and hopefully easier to take in. So let's see where we left off. All right, Judge. Oh, Zoom is here. Okay, Judge Middleton. And this is still landlord tenant matters. This was July 10th, a couple days ago, so we're not too far off from his current docket. And let's see, we're in court. YouTubey things, we're on the tubes. So like, share, and subscribe. All right, so we also know that there was a time he left the live feed on, and in his specific performance case, and Madam Blair was, trying to advance some defenses with her attorney, and they were continuously having a communication in open court. But thankfully, they didn't disclose too much. I don't think anything proprietary was disclosed, but it was really funny to see. Um, just a quick reminder, since things are being, oh, no, not that one, since things are being broadcasted or live streamed, if you will, when you're in open court such as this, do not have confidential privileged communications. There are desk mics. That's what these items are here and here. If you turned them on and the feed is on, we're going to be able to hear you if you're on a hot mic. And then there's also look like a recording device. Maybe this is a recording device and that's desk mic, but nonetheless, those items are there, and if they are on, you can be heard. So you don't see a person, but yet we're here on YouTube, and that's exactly what happened with Miss Blair. She was talking about it. She was advancing some very creative thought process that didn't help her in the end. All right, so when Judge Middleton goes on break, I like to put it on 2, but since he said 20 minutes, that seems like a little long. Let's see if we can jump ahead. I haven't seen him do long breaks. I think he did his lunch break before, but they cut it, so we didn't have to sit and, yeah, he really did leave it on the whole time. Okay, it's 20 minutes later. Okay, somewhere around here. Oh, coming into the well. All right, I'm ready. I'm ready with hearsay. I'm ready for hearsay. Turn it back up. Unplug if it's in your ears. It's loud over here. And the construction workers are not here now, but when they are here, are working. Okay, here. So unplug or turn down the volume. All right, everyone's coming in. Um, hmm. Okay, so their original hearing was 7 days ago, is the reality for Mr. McKee. And Mr. Mrs. Larkins, or the Larkins, however they are identified individually, have opted out of Keystone, is what he said. And Keystone is a third party entity that, from what I gather in watching this, they are like some type of not a Section 8, but because that's a governmental, but they are a entity that comes in and will pay portion of the rent, or um, all of the rent. And that would include the arrears. And this was in place, or put in place, during COVID. So I think that's the entity for Keystone. I know that was for Sarah. I don't know about Keystone, but anyway, that's what he's saying. They said they didn't want to do it because as landlords, you have to opt to receive funds that way, to cooperate with that entity, whether it's Section 8, Keystone, Sarah, whatever, to receive payment on the tenant's behalf. And so tenants may feel like, well, I'm making the payment, so why do you care? You know, where the money is coming from? They're going to care in one regard, that it's legitimate funds, that it's not through fraud, because they don't want to be, wrangled up in anything illegal. The other reason why they're going to care is that, does it require them to do any extra step as a landlord? Or does it require the property to be um, under certain conditions? Do they have to go through a different process to sign up? Do you have to have site visits? Do you have to have clearances? Do you have to have sign-offs? Do you have to deal with this other entity kind of hovering over you, if you will, and making sure, or just giving you extra things to do as a landlord? So they can opt out. They're not required to do it. So if you can find a landlord that is willing to do it, then all the better, but it's not necessarily a requirement. Let's keep it going. Now, if my memory serves me correctly, the Larkins, I think they're the couple that, or the landlords, nonetheless, whether they're a couple or sister brother, I'm not sure, but I believe that they stated they didn't mind working with Keystone, or having him get the check from Keystone, but they have to bring the money. And their issue was, it takes so long and it's not a guarantee. And that was the reason why they weren't signing up, or like, wanting to move forward with it. So he had to be vigorous in getting the the program, the entity, to bring forth the payment, and not sure how he qualifies. So a part of qualifying, even in when you're purchasing a home, there is qualification of the person, the buyer, whether it's an entity, of corporation or individual, or husband, wife, or or a group of people collectively. It's qualification of them, as well as qualification of the property. for first-time home buyers. Now, if you're doing like an income property and you're doing a conventional, you could probably wait. If it's not owner occupied, you could waive the factor of an appraisal of the property. That is under different, different types of lease, what's it called? Lending, like when the mortgage broker is lending money, when the bank is lending you money. So those criteriums can be different. I'm just giving you a very small snippet of what typically happens in a purchase. That's the same kind of scenario with like Section 8 for rental. Now you can purchase with Section 8. So if you have Section 8 and looking to purchase, let me know. I can, if you're not in my state, I can refer you out to someone else who can help you, but you can purchase in Section 8. And so, however, but I'm talking about the landlord tenant side of it. When you are renting your property out as a landlord that accepts Section 8, you're in contract with the tenant and Section 8. And so that's what I was saying earlier. There's some landlords who just they don't want the oversight. They don't want the extra requirements, extra things that may come about it. And he's in a position where he wants to talk to legal aid, which is great. You should. If you have questions, get your legal aid, get your questions answered. But the judge is kind of forewarning him, you're in a situation where it's just a matter of payment. Whether you're paying it, Keystone's paying it, Sarah's paying it, it's a matter of payment in totality at this point. And considering that's not feasible and not getting ready to happen because the landlords are not interested in the programs that you're offering, then by all means be out by the 20th. He knows his people. Like if he's not out working, if you can find him. I, that's how I remembered it. So as much as communication is at this time, Larkins is making sure the court is informed that they are not they're not against, they're not adverse to having Keystone, but they just have conditions relative to having Keystone involved. And their main condition is run me my money. Like, give me the check. It don't matter. Like, give me the check in the right time and we're good. You can stay. But that's nothing different. It's not that different from anyone else's position because any tenant that can come in during this period and give the check in totality has the right to stay. In this type of proceeding, unless it's termination, this is just for eviction for non-payment. So in those circumstances, the landlord is saying, if you cure the illness of not paying, if you pay your arrears and you get caught up to date, then fine, stay. But you only have 10 days at this point to do so. Okay, what's next, Judge? We want some hearsay. We're ready for the hearsay. Hearsay, Law Nerds Unite. Here we are, Emily D. Baker. Okay, got a couple matters on the doc next section block. Is he not? Does he have clothes on? Oh my gosh. Oh no, I guess it's a shirt. I guess TCL looks derobed. I want to get him a shirt or shirt that doesn't look like skin, whichever it is. Super short. Okay. Okay. Is this the one that the gentleman died? Is that what we're talking about? It's like a Michigan code. Bob, stop talking. Okay. So from the sound of it all, this sounds like the case where the original tenant passed away. And so the family, loved ones, or extra ones, whomever, was still occupying the property. Not sure if they were paying, um, but nonetheless, in that circumstance, there was a case, if this is not the one, that the landlord wanted them to vacate and to go into a new tenancy with someone different. They did not want them to stay. So I think that's the particular matter that they're speaking of. They're disseminating a default judgment because the individuals did not show up for court. But I've said this before. Understand this. If the landlord doesn't show up for court, then you probably just gonna get a continuance in this matter, in this particular type of matters. If the tenant doesn't show up for court, then you're going to get a default judgment. Like it's so not showing up does not benefit you. Show up, be heard. There are times that even though you get notice for the 10 days to vacate and before the writ is enforced, which means the sheriff will come out and have you evacuate with all things that you can grab and handle a forceful eviction. So you get those 10 days to get out from probably this particular court hearing. But sometimes you can speak with the landlord and negotiate even more time. I've seen some landlords give 30 days. So the judge will not make you get out. It's a matter of if the landlord wants to invoke their right to have you vacate by the next 10 days, on the 11th day, they can have the sheriff come and evict you. But if they so give you 30 days, then by all means, take the time if you need it. Uh, so the overall point is show up for court because you might be able to negotiate some terms for your eviction that are favorable to you. He's saying he doesn't have a judgment form, like a blank form, so that he can fill out the final judgment and sign it, and then they can immediately get the judgment in the books. That's what he's talking about. Oh, immediate possession. So they don't even get 10 days. So they're past the either they're past the 10-day mark or it's just default that immediate possession. Mhm. Okay. So they can call the sheriff now. And so that kind of solves that question. This sounds like this is their second hearing. Whether they appeared for the first one or not, I don't know. But they did not appear for this one. So um, July 20th is 10 days from now. That is the appeals date, meaning that they can come and appeal this verdict by that time. However, the time that they get thrown out by the sheriff is as early as the next day, the 11th, because they have a final judgment in order right now, the default judgment, so they don't get the extra 10 days of possession. So that is what they're losing in this default judgment, the extra 10 days of possession, which is could be necessary to help you finish coordinating, organizing to go to a new place, or at least putting your stuff in storage and not losing your items, and effectuating a move, as we all may have done so already. So that's what they're losing. They're losing those 10 days. They have to be out now if they're not already. Maybe that's the reason why they didn't show up, already out. Okay, so he has on a tank top, praise all of the Lord. Because I just I was so concerned. And then he's standing up. I'm like, oh, don't let nothing hang out. But I will interject that we are in court. So make sure that you're dressed for court, you're ready for court, you're communicating in a manner professional to court. I don't know how judge feels about tank top, about, yeah, white beaters or tank top shirts. I know that most courts, they're not okay with it. Is it the uncle? So that's so I believe so. Okay, so this is the gentleman whose uncle bought him a house because he was, well, this is his side of events. His uncle bought him a house because he was going through a divorce, not with the young lady he's with now, but whomever before. He's been fixing up the house, supposedly, and he wanted to stay, but his uncle goes, no, it's not about money. He wants to terminate the lease. So he's requiring them to move out, though that they wanted to make the purchase. It was a whole lot of other stuff. So you can watch that video from last week. So I kind of feel he was agitated before. He was a little more animated than he is now. He is quite more subdued than last week's hearing. However, I feel bad for him. It doesn't seem like there was any formalized lease relative to his stay. He felt like it was his house to be had, and the uncle doesn't feel that way for whatever the reasons. Because, like I said, the landlord doesn't have to have a reason for terminating the lease. If your lease is up, they can terminate with you with proper notice, and they can require you to move. And that's the process that they're going through: the proper notice and the proper eviction process to require you to move. So they're within their right to do so without reason, or without articulating a reason, if you will. But I feel bad because he's gotten arrested for, whatever, maybe a fight, maybe whatever it could have been. And it's a very emotional time for anyone that's getting put out of your place. But this is also between family members, nephew and uncle. So that adds another layer of emotions to it. So it's heartstrings are pulled. Gary Lockwood, individual that is named, and all other occupants. They don't care who it is. You are responsible for getting them out. All are to be out. Let them know. Serve them. You can have them served. Don't worry. The sheriff will be there with the writ to get them out as well. Don't get into an altercation, of course. Don't go to jail over it, because all will be well. The sheriff will come with all the enforcement he or she needs to help escort whomever out. So 21st. Okay, so that was the uncle, Mr. Castle. Um, so we have it. There it was. There was a few good little nuggets there. We've been able to have calmer heads prevail from one hearing to the next. So thankfully for Mr. Lockwood, he was a little more biting than originally, because he was going off originally. Um, and that's what it is. Like I said, it's an emotional thing for everyone involved. And my heart just bleeds for the fact that this is the uncle and the nephew. The relationship with them must be changed by some measure. Hopefully they'll be able to overcome it and to see each other's sides, or at least respect the fact that they are able to disagree on the reality of what transpired. But you hate to have family or familial relationships disseminate over real estate or money. But I will tell you this: earlier we talked about having a trust, and kind of understanding that having a will does not cover it all. You need to have a trust to make things implement quicker and more timely than waiting 5 years plus, or 2 years, or extensive amount of time. And obviously you're not here on the earth once you have, the trust goes into effect, but nonetheless, or the will goes into effect, nonetheless, make sure you have a trust. You can see that video. That's the Aretha Franklin video, real short one. This particular instance, you your heart just goes, oh well, just poor babies, because this happens when you don't have a trust, and maybe you have a will, or you have three wills, whatever. But when you don't have a trust, families sisters, siblings, sisters and brothers, and all of that, cousins, whomever is left behind, they fall out. They do. The time can be immediate, it could be extensive later, but there's very few families that are able to still maintain the connection when mama and daddy are gone. So uh don't let that be the reason why they fall out. Have a trust, right? Have a trust. There's no question. And then maybe have a meeting, see what personal property is wanted. Who wants the coat? Who wants the brooch? Who wants the buffet? Who wants, the cabinet, the armoire, the whatever. And that way, everybody gets something and everyone's okay with it. And maybe and hopefully they don't fall out after the fact. But money and real estate comes in between families real quick. So do your best to cover the bases. And unfortunately, this landlord tenant situation just might come in between this uncle and nephew, but we do hope it doesn't. And hopefully he and his new girlfriend are able to find somewhere, because it looks like they're still looking for somewhere to go. All right. Lyric Armstrong, your real estate agent and advocate. We're going to keep on trucking. Come on, Judge Milton. We're ready for the next one. All right. See you in the next video.